Okay. Can you hear me?
Yeah, now it's clear.
Okay. Again, some problem here. Can you hear me now?
Yeah.
Can you see my screen?
Yes, sir. We can see your screen.
There's an echo here.
But I don't know, means whether other participants, because their chat box, they can also able to share whether they are getting echo. If at all, if they are getting. So
Echo है. और उसको ऑफ करो. You can see the.
No, we are seeing the screen PPT now. I think it has to be displayed. You have to select the PPT. Yeah.
You
Yes.
can see
Now
can see the.
Yeah. We can see. Yes.
Okay, I will go through.
Yeah.
See, this is the first knowledge for entrepreneurs and professionals on the RERA. So the rights and duties of the promoter under RERA, let us discuss. So the rights and duties and obligations of the promoter under RERA across India and role of chartered accountants we'll discuss. Are you all able to hear me now?
Yes, sir. Because the participant cannot able to respond, they can only respond through chat.
Hear me?
Yeah. We can able to hear.
GVS?
Yeah. I can able to hear, sir.
Okay. Perfect.
Yeah, perfect.
Chalo. Thank you.
I'll also check with one of the participant whether they are able to hear.
There is an echo happening. I don't know the reason.
Akash is there. Akash, can you talk now? Because I've allowed you to talk. Can you able to respond? Audible? Mr. Akash? Seeing Akash as one of the participants. Yeah, okay.
I'll go through now.
Yeah.
So thank you, GVS Kumar for arranging this program. Let us understand distinct and unique features of real estate across a class of asset or wealth creation. So there is something called durability. Real estate investment can extremely durable and build multi-generational wealth. It is a high-risk area. Large number of frauds are being committed. High startup costs, diversification of funds, illiquid nature of industry, delay in delivery of projects, lack of transparency, and high level of uncertainty. So this is the distinct feature of real estate. Now, real estate has undergone the huge impact that is from the era of demonetization happened in the 2016. Then RERA came in, IBC has come in, GST 2017, Finance Act, lot of amendments have happened. Now the new Income Tax Act 2025 has come. NBFC crisis have happened, liquidity crisis, investors also have left the market, and COVID. So this way, there are so many things which are happening. Now, laws which are governing real estate, if you have to look at the laws which are governing real estate, it started with the Contract Act 1872, which has got a general provisions related to the contract. Thereafter, as a specialization came Transfer of Property Act 1882 and then Stamp Act and Registration Act 1908 to take care of the property transaction. Then Land Revenue Code. Different states have different Land Revenue Code and State Rent Control Act, which have started, recording the properties, real estate, and the land, buildings in the land record. And then various state governments enacted State Rent Control Act for the purpose of creating a tenancy in a multi-story building. Later on, Cooperative Societies Act 1912 has come in, and of course, respective states have also enacted their own state act from the year 1919. Now, these cooperative societies have enabled the people to come together, form a housing society, own the land, and construct the building and allot the flats to the members. And Maharashtra is the first state which enacted Maharashtra State Ownership Flat Act and Maharashtra Apartment Ownership Act. Similar provisions started enacted across India. Consumer Protection Act 1986 was the first act to protect the consumers, including the flat buyers. And in the year 2019, new Consumer Protection Act has been enacted in order to take care of the consumers. Various developments across India is happening under the Country and Town Planning Act. Respective state governments have enacted. Maharashtra has enacted Maharashtra Regional Town Planning Act. Then there are various direct and indirect tax laws which are applicable, whether it's income tax, GST, and various other laws, which you can see. So this way, the real estate is getting governed under the various laws, and it is only few laws which I have enacted, shown here, but there may be anything. But then in the year 2016, we got a special law to take care of multi-story buildings where the flats or the apartments are sold to the different people, and the landowners and the builders, promoters started selling. And in order to see that real estate get properly regulated, in the year 2016, Act was amended, and from 1st May 2017, the real estate got enacted. Now, under the State Ownership Act, various states have enacted their own ownership act, which was giving the apartment owners a statutory right to demand the land and building relevant papers, get the agreement registered on payment of 20% or more amount, agreement in a specific format, maintain the property till the society is formed or RWA is formed, land and building is transferred, conveyed to RWA, promoters' builders are made accountable and responsible under the State Ownership Act. So one could demand specific performance, whatever the obligations are casted against the promoters or against the allottees. Either of them can demand specific performance by either of the parties. Non-compliance by the promoter was considered as a default and is considered as a criminal offense. And the remedies could be coming through civil code, criminal code, consumer code. So this is how the state government was getting various laws enacted, and then the builders or the promoters made responsible. Now the era came in RERA, Act 2016. Here, the duty of the promoter to disclose various documents and plans are made compulsory. Real Estate Regulatory Authority has been set up, and to hear the compensation, adjudicating officer is appointed. If both the authorities' orders are passed and if they are not, acceptable to either of the parties, they could file an appeal before the appellate tribunal. And then second appeal was going to the High Court, and Supreme Court was hearing under the special leave petition. So this way, the hierarchy of the RERA, appellate tribunal, High Court, and the Supreme Court for the dispute redressal also could be seen. So the protection And the risk in the real estate depends on the status in the RERA. So ultimately, who are you in the real estate transaction? What is your status? Where do you stand? So therefore, the RERA has made basically 3 segments who are made accountable and responsible under RERA. Who are they? For each of the stakeholder, there are certain rights, there are certain duties and certain obligations. Today we are touching upon the rights, duties, obligations of the promoter. Because at the end of the day, whatever is the obligation of the promoter becomes naturally the rights of the allottees. So therefore, if you see this slide, we have put 3 different boxes. One is the promoter, second is real estate agent, and the professionals, which is the people who are going to either happen the transaction or mediate between the authorities and the promoter or the allottee, that is the professionals, contractor and other agencies connected to the real estate project. And then we have allottees. Now, if you look at the promoter, we have 2 set of promoters. One could be considered as a landowner or a builder or a developer. So one who owns the land and appoints a contractor, considering him as a developer, and enter into a joint development agreement. This can be one set of promoter, and then this promoter can be registered under different bodies. It could be in the form of individual, firm, HUF, company, associate persons, government, semi-government, local authority, trust, society, cooperative society, or LLP, or any other body which may be registered or unregistered. So these are all considered as a promoter. Then we have an allottee. Allottee can also be a single or a group of persons. Again, the group of persons can be various organizations, associate persons, which I spoke. Similarly, agents also can be individual or firm or company, and this is how, even for example, real estate, various professionals are there, like chartered accountant, company secretary, cost accountant, advocates. This also can be a form of firm or an individual. So this way, it all depends on where you stand in the transaction. So a compliance under RERA, there are basically 5 compliances which we can look into. One is project registration. Real estate project has to be registered. Real estate agent registration. Filing of the complaints. Financial discipline is very important, and transparent and consumer-oriented approach. Now, if there is an investor in the land or a developer company, what are the risk and responsibility? And what are the compliance to be done? What are the duties? The first duty is under section 3 of RERA, where project requires to be registered. So when the project is required to be registered, we will look into it one by one. Yeah. So the project has to be registered regarding the development of any immovable property in together or in phases. So if the projects are getting registered in phases, then also for each phase there has to be applicable land. Without the land, project cannot be registered. So then the question came in whether the projects which are ongoing at the time of enactment of the law, that is, or commencement of the law, that is 1st May 2017, whether all ongoing projects also requires to be registered where the occupation certificate is not issued. So therefore, the RERA has made a provision that all pending projects which is also called as ongoing projects, where OC is not issued, they also need to be registered. So this way, from 1st May 2017, there are 2 types of projects which started happening, registering. One is the new project, which has to be registered before it is offered for the sale or advertised, marketed. Second is when the projects are ongoing and the completion certificate or occupation certificate is not received, they also have to be registered within 3 months from the date of commencement of the act, which means the 1st May was the commencement. So May, June, July. So by 31st July, they were required to be getting registered 31st July 2017. Now, naturally, whenever we pass any general law, there has to be certain exceptions. So what are the exceptions? Exception means which are the projects which are exempted from registration. So there are 3 exceptions which are given for the exemption of the project registration. One is if the land area and the number of units which are going to be constructed and sold is less than 8 units, or the area of the land is less than 500 square meter, then they don't require registration of RERA. Which means any project which is more than 500 square meter and having more than 8 units, they require registration. Secondly, at the time of commencement of the act, if the project has already received the completion certificate, then they don't have to register under RERA. Third is renovation or repairs which does not involve reallotment and marketing. If there is no reallotment or marketing is to be done, then again project need not be registered. So these are the 3 exceptions which have been said in the RERA. Now, if I have to register a project as a promoter, and then what are the things I need to look into? Naturally, one, the promoter need to share a lot of information, disclose various information as required in the section 4, and of course applicable rules. Each state government has their own rules, and each RERA has their own rules and regulations. Based on that or the circulars, they call for various information. And then every RERA also has prescribed the fees to be paid. Now, across India, RERA is getting registered online. Maybe 1 or 2 states, still the website is yet to be done. But otherwise, almost all the states and the Union Territory RERA are now presently operation online. Now, at the time of registration, you will have to see what is the number and size of the layout or the phases. How many phases you want to do? What is the layout? What is the size of the layout? Then propose project. How the project you are going to propose? Is it a residential, commercial, mixed use, plotted development? Then approval in the each phase. What are the approvals you are issued? Declaration has to be given by the promoter. When he is giving the declaration, he has to mention at least 4 of these, what I have said here. 1, he has to declare that his title is clear, it's free from encumbrances, and if there are encumbrances, he has to upload that information. Then also, he has to upload specimen of agreement for sale, conveyance deed, as well as allotment letter, which will be issued to the allottees. Then he has to declare when the project will be completed, and schedule of completion, milestones. Third, project to be completed in what period? The period which you are mentioning in the project, it has to be less than the period allotted by the competent authority. As we know, the municipal corporation or the planning authorities will give the approval. We are considered as a competent authority. If they have given the approval saying that your project has to be completed within a period of, let us say, 5 years, then you cannot get the project registered beyond 5 years. Similarly, he has to declare that 70% of the money which he is receiving from the allottees will be deposited in a separate bank account, which will be opened in the scheduled bank, and this will be met only for the cost of the project. What do you mean by the cost of the project? Cost of the project means the construction cost and the land cost. So the entire 70% of the allottees' money will be deposited in a separate account, which will be utilized for the land cost and construction cost. Again, in the declaration, he says that at the time of withdrawal, he will submit 3 professional certificate, independent professional certificate to the banker to withdraw the money from the 70% RERA destination account. Who are these 3 people? Naturally, a chartered accountant, architect, and engineer. Architect for the percentage of completion of the project as per the approved plan. Estimated cost of the project completed by the engineer and the chartered accountant to verify from the books of account how much money has been spent on the land cost and construction cost. So the incurred cost will be certified by the chartered accountant. Now, having said that, once you apply for the project registration, Section 5 talks about granting the registration. Within 30 days from the date of application, the project, the registration has to be granted by the authority. In case there are some issues or some requirements are missing, then within 30 days, the authority has to inform the promoter the pending compliance. Then within 30 days, if it is not done, then naturally this project is considered to be deemed registration. Then under Section 5(1), Clause B, the compliance is not there and the project is not registrable, or if there is not an approved project or it is not sanctioned project by the common authority, that is a planning authority, then they can reject it within 30 days. And then Section 6 talks about that extension. Now, once the project is registered, the authorities naturally give the project registration number. They are also given a login and password for accessing the website. And then in that website, the project completion schedule also will be given. Based on this password and login, the promoter will be able to update the details of the project regularly. Now, under Section 6, the project extension is possible for a period of 1 year if there is a force majeure. Now, under Section 7, the project can be revoked or it gets lapsed if the project is not completed within a period as declared by the promoter at the time of registration of the project. Project can be cancelled on the basis of the complaint by the stakeholder and that there are some unfair trade practice adopted. Similarly, based on certain audit report or public information or a press report, even the authorities can suo motu cancel the registration. Now, if the project is cancelled or revoked, then naturally promoter is debarred from accessing the website. Complete the project need to be completed by the assigned allottees. And if the assigned allottee does not come forward, then the authorities need to get it completed through the either common authority by the help of state government and declare the defaulter and display his photo all the state website, and whatever money is there in the 70%, that will be frozen and it will be handed over to the person who is completing the project. So this way, obligations. Now let us look at the obligations of the promoter or the landowner. Section 3 we just discussed. He has to register the project before selling any units or offering it for the sale. Secondly, under Section 4, he has to give various project detail, including 5 years track record. Section 4 also says, by way of a declaration, money has to be deposited in a separate bank account in a scheduled bank to be used for land cost and construction cost, which has to be utilized only after certified by the architect regarding percentage of completion of the project, engineer about the estimated cost of the project completed, and then chartered accountant regarding the money incurred. So whatever money has already been incurred in the land cost and construction cost, that may be withdrawn from the RERA separate account. Then once in a year, the promoter also has to appoint a new chartered accountant, a separate chartered accountant, who will be able to get the accounts audited, and this audit report will be in a prescribed format and should be completed within 6 months from the close of financial year and should be uploaded. So under Section 11, the promoter has to disclose on quarterly basis various project details, whether it is how many flats are booked, apartments are booked, how many garages are booked, what is the status of construction, what is the money collected, how it has been spent, and this is called quarterly progress report under section 11 of RERA. Now, under 11, it also says once the number of apartments booked is more than 50% of the total sanction plan, as per the sanction plan, then it's the obligation of the promoter to register the society or association of allottees. And if section 12 says, if the promoter has given some wrong information in the advertisement, misinformation, then he is liable to refund the money to the allottees if it is so demanded, along with the interest and compensation. Now, section 13 says the promoter has to register the agreement for sale with the sub-registrar the moment he wants to receive more than 10%. Whenever the promoter wants to receive more than 10% of the agreement value, he has to register the agreement for sale. Similarly, section 14, there are 3 subsections. The subsection 1 says the promoter has to comply and complete the building as per the sanction plan. Secondly, if at all he wants to make any amendment to the plan, then he has to receive 2/3 allottees consent. Subsection 3 says, in case there is any defect in the liability in the construction or defect in the construction, then the promoter is required to rectify the defect within 30 days from the date of intimating such defects by the allottee or by the allotee. So this way, the 5 years period starts from the date of possession. Now, section 15 says the promoter, if he wants to sell his project to a third party, then he also requires 2/3 allottees consent and also approval from the authority. So without the approval authority and 2/3 allottees consent, a third party right cannot be created. Section 16 talks about 2 types of insurance which the promoter has to take. The first is title insurance, because the land is the one which has a title, and if there are any defect in the title, then there is a compensation payable by the promoter to the allottees, and therefore it is always better to take a title insurance. Second is a building insurance, that is a construction insurance, also can be taken under section 16. Section 17 says that promoter has to convey the title of the land and building within 3 months from the date of OC as per the local law. Section 18 talks about 2 particular obligations. One, the promoter has to hand over the possession of the premises as agreed in the agreement for sale within the date mentioned in the agreement for sale. In case he does not do it, in that case, there are 2 remedies which are available to the allottees. One is the allottee can ask for the refund along with the interest and compensation. This is one remedy. Second option is the allottee may continue to remain in the project, and then he can ask for the delayed interest on the amount paid to the promoter from the date of possession till actual date of possession received with the occupation certificate. This way, the section 18 is a draconian section, and a lot of complaints we have seen, the projects are not getting completed in time, and therefore many of the allottees are invoking section 18, and more than 80% of the complaints are only on section 18. Now let us come to the regulatory authority. When we talk about regulatory authority gets the, as a screening authority. Why screening authority? Because they are the authority who are in between the promoter, that is written is number 1, and number 3, allottees or the flat purchaser. So the authorities become a screening authority unless until the promoter completes all the information required to get the project registered. They will not grant the registration, and if the registration is not granted, naturally buyer will not be able to buy it, neither the promoter is able to do the advertisement and sell. This way, the preventive measures are taken by regulatory authority. Duties of the promoter, the next important is what are the rights of the allottees or what are the duties of the promoter towards the allottee. So this is the second. Till now, I was talking about obligations of the promoters, which we have seen section 3 to section 18. Now let us come to the duties of the promoter. Now when we talk about duties of the promoter or the rights of the allottee, they are all matching. So right to get the information of document, sanction plan document, these are right of the allottee, and it becomes the duty of the promoter to give it to the allottee. Similarly, right to get the completion, occupation, lease, and all this certificate has to be, so that means promoter has to give it. Similarly, the promoter has to comply with whatever is been agreed in the agreement for sale, and he has to rectify the defect in the title, and he cannot create any breach in the agreement. And that means if there is any defect or breach, naturally the allottee has a right to claim compensation, and it is a duty of the promoter to give the compensation. Then alteration, transfer to third party, registration revoke, all these also. The right to withdraw from the project which is there, which means once the allottee says that I want to withdraw, it becomes the duty of the promoter to refund their money along with the interest and compensation. Right of execution of satkat, that means the agreement for sale or conveyance deed, all this has to be done by the promoter. That becomes the duty of the promoter, and it becomes the right of the allottees. So the moment he receives more than 10%, he will have to register the agreement for sale. Now, we have seen the rights of the allottees. Then the question is, the third, aspect that I'm going to cover today is fundamental rights of a promoter. What are the rights of the promoter? Because at the end of the day, the RERA is a regulatory authority to regulate the transaction between the promoter, real estate agent, and the allottees. And if this transaction has to be regulated, each of the stakeholder in this transaction has to have certain rights and certain duties and obligations. And if those things are not done, naturally the punishment. And who is the person who is going to regulate? Naturally, regulatory authority. Therefore, we have a RERA. So let me straight away come to, I have listed about 10 duties, rather rights of the promoter. First right is to receive the agreed consideration. Correspondingly, when we talk about agreed consideration in the construction linked payment schedule or milestone agreed between the parties, whatever way, and if that is not done, naturally the promoter has a right to go to the authority and either terminate the agreement or receive the consideration with the interest. So correspondingly, there is an obligations of the allottee to make the payment. See, section 19, subsection 6 talks about the obligation of the allottee to make the payment in the manner and within the time stipulated in the agreement for sale. So this way, the rights of the promoter becomes the obligation of the allottee. Earlier we have seen duties of the promoter become the rights of the allottees. Now let me take you to the next is right to interest for delayed payment. Section 2 ZA speaks about interest for the delayed payment. The interest for the delayed payment for both, whether by the promoter to the allottee or allottee to the promoter, has to be same. And therefore, section 19 subsection 7 talks about an allottee delaying payment is liable to pay interest at the prescribed rate. That means allottee has to pay the interest for the delayed payment, which means the promoter has a right to receive that interest. An important principle under RERA is a reciprocity, which means interest rate chargeable by the promoter to the allottee cannot be higher than the rate payable by the promoter to allottee upon promoter default. So both, as I said, we'll have to charge same rate of interest. Now what has happened is various state governments have enacted in their state law what should be the penal interest. The penal interest is SBI's marginal lending cost plus 2% in Maharashtra. In some of the state, it is SBI's marginal cost of lending rate plus 1%. So it all depends, but maximum is SBI's MLRC, marginal cost of lending rate, plus 2%. Now, another third fundamental right of a promoter is to cancel the agreement cancel the allotment letter or allotment of the flat as per the agreement. What happens is, if the allottee does not make the payment, then he cannot wait for a long, and there are other stage-wise construction milestone has to be complied. Even 3, 3, 4 reminders, everything is done, still it is not done as per the agreement. In the agreement, there is something called the milestones payment, and at what stage the promoter can terminate the agreement. And this is as per section 11, subsection 5, which recognizes the promoter right to cancel an allotment. But cancellation must be strictly conforming to the agreement for sale, whatever clause written there in the agreement for sale. It cannot be arbitrary. It cannot be unilateral without contractual justification. There must be sufficient cause. And allottee can challenge improper cancellation. It is not that once the promoter cancels, it becomes full and final. The allottee can always challenge this cancellation before the real estate regulatory authority, and thus cancellation a contractual right controlled by RERA, standards of fairness and legality, is also done by RERA. So this is how the promoter has a right to cancel the allotment of the flat, apartment, as per the terms of agreement. Now the fourth is, as I was saying, the promoter has to register the project for a particular period. Now, if the project is getting delayed, or because of the war, flood, drought, fire, cyclone, earthquake, or any other natural calamity, the promoter is not able to complete the project, he has a right to ask for the extension. Just to give you at the time of COVID, the central government allowed initially 6 months extension, and during the second phase of the COVID, further 6 months is given. This way, 1 year extension has been given during the COVID. Now, because of the war, Iran and Iraq, between Iran and Iraq supported by US, so further 4 months, extension has been recommended by the central government, and naturally, each of the RERA authorities have allowed 4 months extension under section 6 of RERA. Fifth right is to hear before rejection of registration. See, as I was saying, under section 5 of RERA, the project registration can be rejected if there are no compliance done. In that case, the real estate regulatory authority need to give an opportunity to the promoter to hear, and therefore right to hear before rejection of a registration is also one of the fundamental rights of the promoter. Sixth is right to hear before revocation of registration. As I was saying, section 7, if the project promoter does not comply, or there is some unfair trade practice or fraud is played, then the registration can be cancelled. So at the time of registration cancellation, the promoter requires to be given notice. So this way, the promoter has a right to hear from the authority even before the project is getting cancelled. Then, right to transfer the project subject to consent. Yes, section 615 we have seen, promoter has a right to transfer the project subject to consent of 2/3 allottees, which we discussed. Again, the approval from the authority. Transfer remains possible, but it is regulated. So next is right to appeal against the RERA order. If the RERA has passed the order under section 43 and 44, an aggrieved promoter can appeal the order of RERA authority as well as adjudicating officer. So naturally, provision to section 43(5), he may have to pay certain deposit, and in that case, 100% of the deposit to be made, what is payable to the allottees, and at least 30% or more percentage as may be directed by the appellate tribunal towards the penalty. So one, it can be 100% money payable to the allottee, like refund money or interest payable. In the case of penalty, it is only 30% or more as may be determined by the appellate tribunal. So this way, the requirement has a strong judicial affirmation, and there is a right to appeal also. The right to appeal to the High Court, there is a second appeal under Section 58, where the appellate tribunal order, if you are not happy, you can appeal before the Honorable High Court. And even the authorities or the RERA has provided the right to professional representation. So a promoter can hire the advocate, chartered accountant, compensate cost accountant, or any other authorized representatives to appear before the authority or adjudicating officer or appellate tribunal, and then of course before the High Court and Supreme Court. So this way, right to professional representation also there. Now we will get into the next, risk of offences and penalties. So I'm at the fag end of my presentation as to what are the various penalties. Because at the end of the day, if there are obligations, duties, and other things, and you have fundamental right also, then what are the penalties? First is, if the project is not registered and you are going ahead with the sale to various people, which is prohibited under Section 3, then penalty can be up to 10% of the cost of the project. Under Section 59, subsection 2, if there are certain information is required to be given, and if you are not given, or they are contrary to the what has been mentioned in Section 3, then the punishable term may be extended up to 3 years, or fine, which may extend up to 10% of the cost of the project. So all the penalties are based on the cost of the project or the cost of the flat. So if you are, Section 60 says, if you are giving wrong information, then at the time of registration or thereafter, then 5% of the cost of the project is levied as a penalty. Or if you are contravening any of the provisions of the Act as a promoter, then 5% of the cost. Then non-registration of a estate agent or contravention of Section 9 and 10, in case there is Section 9 and 10, which is talking about project, every real estate agent, before selling any apartment, he should get registered with RERA. And Section 10 talks about various functions of real estate agent. In case real estate agent does not perform the duties or does not get registered and he starts advertising or selling the apartment, then 10,000 rupees for each such default per day will continue % of the cost of the project. Then failure to comply with the order of the authority by the promoter. If the authority promoter fails to comply with the order of the authority, then again 5% of the cost of the project can be levied. Similarly, failure to comply with the appellate tribunal order by the promoter, 10% of the cost of the project or 3 years imprisonment. 65, Section 65, failure to comply with the order of the authority by the real estate agent. If the real estate agent does not comply, again, penalty of every day, and it can continue up to 5% of the cost of the project. Similarly, failure to comply with the order of appellate tribunal by the real estate agent, then 10% of the cost of the apartment which has been sold or the imprisonment of 1 year. Failure to comply with the other order by the authority, even the allottees. If the allottees also fail to comply with the order, then penalty up to 5% of the cost of the project can be levied. So this way, if the allottee has failed to comply with the order of the tribunal, then 10% of the cost of the flat can be levied as a penalty. Section 69 talks about offences committed by the company. In case company has committed some offence, naturally, every director and manager who is liable to discharge the duties shall be considered committed offence and shall be accordingly made liable to pay. Section 70, 71, 72 is regarding the one is compounding of offence by court levying penalty as per the rules. The rules have provided whatever is the penalty, up to that amount, that whatever is the offense, once the offense is committed, whatever penalty, what we had discussed, section 59 to 769. So whatever penalty has been levied, to that extent, the compounding offense is possible, and that is what is provided in the rules. Now, in section 71, the adjudicating officer can decide to pay the compensation under section 12, 14, and 18 and 19, where the promoter has failed to discharge their obligations. So the section 72(6) various factors to be considered, which means what is the loss incurred to the allottee, what is the benefit encashed by the promoter, all this will be verified and according compensation will be given. Now let us, whatever we discussed, I have to summarize now. So the summary is key impact area and imperative for successful transition. The first impact area is in the business practice, because we are talking about a promoter. So therefore, what are the impact area for a business practice? One is project to be registered, disclose all the information. Utilization of fund, only 70% has to be put in a separate account. Promoter responsibility to complete the project, form the society, register the agreement the moment you receive more than 10% of the cost of the apartment. Rights and duties of the allottee like refund, everything has been well defined. Consent of the buyer is required for modification. Defect liability of 5 years. Real estate agent registration. Now, because these are the impact areas, naturally, business process has also changed. Now, the promoter need to be very careful that even before launching the project, he should look into legal and regulatory compliances, planning and designing aspects, sales and marketing, finance and accounts, construction and quality. Because each of the things are very important, because either in the form of act or in the rules or in the regulation or by various notification, each of these aspects are getting covered, and therefore the promoter need to be very careful. Then imperative successful transition from non-regulated to regulatory sector. Now developer need to revisit the business practices, operating model to transfer and navigate smoothly in the regulated environment. Because once the any business so it will have a lot of impact. Then is also where the at the time of registration project, as I was saying, the promoter gives a declaration that 70% of the money will be used for the land construction cost, and that is how it will be done. And there are enabling rules and accountant and architect is most important. I'll give you some example just to tell you that cost of construction and land cost is what is taken as a base. Other cost is not taken as a base for the purpose of withdrawal. Therefore, 220, 220, 130, 130. That is how the maximum amount which can be withdrawn. But remaining amount, say 5 crore in the case of scenario 1, and in the case of scenario 10 crore, which is incurred towards other costs, cannot be withdrawn from the RERA account. So the percentage is also given, which is calculated out of estimated cost is 275. So what is incurred is 220. Into 100, that means 80%. Similarly, in the scenario 2, 130 upon 275, because what is percentage of completion is 47.20. So this way, the amount withdrawal is permitted. Now let me straight away come to some of the judicial judgments. In the real Kamal Realtors, it has been made clear that the constitutionally RERA is valid and all ongoing projects required to be registered and all disclosure has to be done. So this is about real Kamal Realtors judgment, which was held by Bombay High Court. New tech promoters and developers is another thing where Supreme Court has upheld refund of an interest jurisdiction, which is with the RERA authority. Similarly, mandatory pre-deposit to be paid by the promoter when you are going the appeal. So, and also in the new tech developers, it has been made clear that ongoing project requires to be registered. Imperious structure is another judgment where RERA remedies coexist with the consumer remedies. So in the case of imperious structures, the Honorable Supreme Court has said that RERA and consumer, they are the two parallel going on, but you cannot file the complaint at the same time at both the places. You have a choice as a consumer. So in the case of EPCE, okay, so Forum of People's Collective Efforts was the state of Bengal. When the West Bengal enacted their own law, the Supreme Court said once there is a RERA which is enacted by the union government, there cannot be another side. Similarly, in the case of Pioneer Land Developers, ERIO and Experian, where the Supreme Court has said one-sided builder development cost does not protect the promoter. So project lifecycle compliance one has to look into at the time of title due diligence, registration of the project, collect 100% and put in 70% account. So collect 100% rule till that you have to not to register the project, agreement, but once you receive more than 10%, you have to register, and then 70% has to go to in the RERA account. Build according to the sanction plan and OC and convince is important. High risk areas, pre-launch marketing, wrong carpet area, false promises should not be given. Diversification of funds and incurred professional certificates, unilateral plan, amenities and position without OC. Non-conveyance, defect rectification and non-compliance with the RERA order are going to be a strict this one, and therefore a promoter compliance audit should begin with these 4 clusters. Now, across India, what must be checked state-wise? Prescribed interest rate and agreement for sale format, project update formats, bank account directions, withdrawal formats, extension, project transfer, last project procedures, complaint forms, fees, circular FAQ, and local conveyance law one has to look into. The RERA is a central law, it is a national law. However, compliance is a state specific. So therefore, promoter compliance is a continuous obligation from title to 5-year defect liability. Best practice is maintain a project-wise statutory file, financial file, technical file, and litigation file so that the promoter is able to do in a better way. And this is the photograph where I had an opportunity to discuss about Maharashtra Real Estate Regulation and Development Act with the Rashtrapati when I visited the Rashtrapati as the president guest. Some of my books, I had written about 40 books. Few important copies of the books were available, which I shared with the Rashtrapati in the Rashtrapati. So this is all about Viksit Consulting, the first webinar related to rights and duties of the promoter under RERA. And GVS Kumar, thank you very much for moderating the session. And I will be able to take question and answer if they are there in the chat box. So what I find, yeah, please go ahead. Yeah, any questions?
Yeah,
Those who want to ask questions, they can ask in the chat box. Okay. I do not have any questions. So Sanjeev Ora has posted, very nicely presented, always in simple and lucid manner by C. Ramesh Prabhu. Thank you, Sanjeev Ora. And any questions, GVS, you have?
No, I think we can conclude. I've just shared that because we have not received any questions in the chat box. So let us conclude, sir. Yeah. So thank you very much, sir. Yeah, for sharing your valuable time and experience and practical insights with us. And I'm sure that these insights shared during this session will be certainly helpful for the participants, to develop a better understanding on the rights, duties, and responsibilities of as a what do you call representing the promoters. As this is our first session as a part of our Viksit Knowledge Webinar Series, so this is not going to be a conclusive session. It's the beginning of a continuous journey of knowledge sharing, professional dialogue, and learning. So I think we have posted the feedback form. I request the participants to share their feedback so that will be helpful for us to make our future sessions more relevant and useful. So we look forward to your continued participation in the forthcoming events. And thank you once again, sir, for your valuable time. And I also would like to thank the participants for taking out their time and then joining us with us. And have a pleasant evening. Thank you so much.
Okay, one minute.
Yeah.
There are two questions.
Okay.
If a small development is required without registration of RERA, and the client also not asking them, which authority is checking? Great. Chandramohan, up to 8 units and land area is less than 500 square meter, you are not required to get the project registration. In that case, as far as Maharashtra is concerned, we have in Maharashtra Ownership Flat Act 1963. So that law gets regulated. And of course, there is a consumer code, civil code, all those are anyhow there. Similarly, in other states also, there are other laws, state laws, which becomes binding. So now you are talking about 40 units. Whatever the land size, if the units are 40, if the land size is less than 500 square meter, then they don't require registration. Even the number of units, both the conditions should be fulfilled. If the area of the land is, say, 480 square meter and number of units is 40 units, then RERA registration is not required. So this is what Maharashtra has said, and the appellate tribunal also has confirmed. And one of the judgments of the High Court also says that it is both the conditions should be fulfilled to get the project registered. So thank you very much. And on 3rd September, every Friday we are going to have the webinar, and 3rd September is we are going to have a second webinar on the what is known as AI. AI, how the AI can be used by the professionals as well as by the